Good morning, Mr. Șușu, and good morning to everyone excuse me, at today's public hearing of the Prosecutor Vetting Commission. My name is Christopher Lehman. I'm the chairperson of the commission, and I declare the session to be open. And I'll give you a minute to make sure you've got the correct interpretation. It's working? Good. Our commission is established under Law 252 of the External Evaluation of Judges and Prosecutors. Under Article 22, Paragraph 13 of that law, provides that this commission will assess candidates for the Superior Council of Prosecutors Selection and Evaluation Board according to the procedures and criteria regulated by Law 26 of 2022 on measures related to the selection of candidates for the position of members on the self-administration body of the prosecutors. The hearing's also being conducted under the Commission's rules of procedures for evaluations under Law 26, 2022. The subject of today's hearing is Constantin Șușu, a candidate for the Superior Council of Prosecutors Selection and Evaluation Board. And Mr. Șușu, I'd like to extend a welcome to you on behalf of the Commission. I'm joined here today by my colleagues from my right, Nadezhda Hryptievsky, Irmantas Mikalonis, and to my left, to my far left, Cornel Lebedinsky, and immediate left is Saskia de Vries. The Commission is also assisted today by members of our Secretariat. The hearing is open to the public and members of the media. The hearing will be conducted in Romanian and English with interpretation. To allow for accurate interpretation, I would ask you to speak slowly and clearly. The proceedings are being recorded, and the recordings of the Commission's public hearings will be available online at the Commission's website, which is www.vettingmd.org, within 3 days of the hearing. Mr. Șușu, during the hearing, one or more members of our commission will ask questions to you. I would ask you to please answer them truthfully and completely, as your explanations are important to the commission in verifying financial and ethical integrity. In formulating our questions, we will take into account your privacy and, where required and possible, privacy of your family members and close persons. So that means we'll leave out unnecessary details relating to ID numbers, bank account numbers, specific addresses or street names of real estate, and the like. And for your protection and privacy, we would ask that you do the same in answering questions. At the end of the hearing, we'll provide you with additional time to make any kind of closing statement that you'd like to. I'll start by briefly reviewing the evaluation process for Constantin Șușu. The Commission initiated its evaluation process on the 22nd of December 2023 by notifying you by email and asking you to complete and return an ethics questionnaire and a financial declaration form. You did so, and you returned the completed questionnaire and financial declaration on the 29th of December 2023. As part of the process of evaluating the subject's ethical and financial integrity, the Commission also obtained information from a number of other sources. Those include National Integrity Authority, the State Fiscal Service, General Inspectorate of the Border Police, other public institutions, financial institutions, and public sources. The Commission assesses the information it obtains from these sources for relevance and reliability. The Commission also sent you 3 rounds of questions, the first on the 28th of March, the second on the 22nd of April, and the third on the 17th of May, and you responded to all of those. On the 22nd of May 2024, the Commission invited you to attend today's public hearing, and at that time we notified you of specific topics that we would be addressing at the hearing. Mr. Șușu, again, we thank you for appearing today. I'll begin with a couple of questions, and I ask you to respond in a complete and truthful manner to those questions. First, I'd just like to ask you if you have any additions or corrections to make to any of the answers that were provided by you to the Commission's request for information.
At this moment in time, there's nothing that I would like to add. I was honest in my communication with the Commission, and the information that I had, I shared with the Commission. I tried to be as diligent as I could. Thank you.
Let me clarify that the answers provided by you in the 5-year declaration and the ethics questionnaire that you returned on in December, on 29th December 2023, are still accurate as of today.
Yes, that is correct.
So I will yield the floor to my colleague, Saskia de Vries, who will follow up with some additional questions for you. Thank you.
Good morning.
Good morning.
I have been practicing your name, Mr. Șușu, so I hope you appreciate that. I have 5 issues that I want to talk to you about. 3 are more important than the last 2, so let's start with the first one, and that is the plot of land in Singere that you have applied for and received from the municipality a long time ago. The information that we have is that you received a plot of land, or you applied for a plot of land, you got a positive decision from the municipality, and the land was signed over to you in 2012. Is that correct?
Yes, this information is correct. The decision of the local authority of the collegiate body that looked into that application of mine regarding the land plot, that came in February 2008. But the land was actually given to me when the title deed was developed, one that authenticated me as an owner in 2012, that is 1 year, 4 years and 1 month, and a few months later. But all this time I was in active communication with the local authorities. We've had open, loyal, sincere communications. They were understanding. And the decision of the council at that time was supposed to be enforced, but at that time they were saying that there was not enough land plots, there were not available land plots that they could give me, given that we were a newly established family.
How and why did you apply for this plot of land? What was the procedure?
In fact, after, well, I went to Sângere district after I've graduated from the faculty as a young prosecutor. And my wife, too, after she graduated university, she went to work there as a young specialist. She was a teacher in one of the schools in that settlement. So after we registered our marriage in October 2007, given that the land code contained a provision, Article 11, that provided for my right to be given for free a plot of land for building a house and annexes or gardens. At that moment in time, it was necessary only, well, I had the need for improved conditions. More than that, I actually didn't have a place to live. I had the right of habitation in the house of my in-laws, and that was actually in Sângere town on 17 Krylov Street. That's what we were staying, and I used that right because my former wife came from that particular settlement, and I and her applied with the public authorities. And at that moment in time, I was meeting all the conditions, all the criteria. I didn't have a different place of my own to live, and we were married, and thus my application was granted.
Thank you. Now, do you know what the purpose of the municipality was to give out land to people in Sângere? What was the idea behind it?
Yes, certainly. At the time when the decision was passed, same as in your case too, I wondered about the obligations that were imposed by the town council. There was the obligation that within a month I was supposed to have the layout drafted, within a year to start the construction, and within 3 years the house was already supposed to be habitable, fit for occupancy. But as I said throughout my communication with the public authorities, when we would go to talk to them personally, I was trying to be as open as I could. I was trying to be understanding myself too. I was trying not to, I was not making abuse of my status of a prosecutor, as a prosecutor in that settlement. So I did ask, I said, in my situation as a young prosecutor, my wife is a young professional, a teacher, and the salaries at that time were really very small, and obviously, given those conditions, we've had some discussions, and they said there were some provisions from some previous decisions, and actually nobody is pursuing the enforcement, or nobody is pursuing the meeting the conditions imposed by the council. And there was a body that was responsible for enforcing the decision of the council, and I mean the mayor. And he assured me verbally. They said there were no precedents for land to be withdrawn because the obligations were not fulfilled. And they said that there is no risk for you, there was no risk for me. All the more so since the local public authorities has the possibility to give that land to you because there are some cadastral works going on. They're trying to look for a place outside the built-up area of the town to give that to, actually they were looking for land plots to give to several families, and they said please be understanding and just wait for it because soon we will have this matter solved. And then the matter was solved, as I said, 4 years and 8 months later. And when I was given this title deed confirming myself as an owner, I registered it in the register of landowners, and then as I explained the commission, several circumstances emerged that were exceptional, I believe, and personally I did not come in front of the commission to ask for emotional empathy, but what actually happened in the near future after that, from my point of view, that is, I believe, justifying my contact. When the commission asked the questions, I realized I understood what questions I have to answer. So when I previously...
Can I interrupt you? Because we will get to that. So if you follow me in your questions, we will get to the conditions. Okay. So to bring back your answer, you said, I applied for this plot of land because I had a family and we needed a place to live. Is that correct?
Yes, certainly. I didn't actually have a place to stay. I had the right of habitation to stay in the house of my in-laws. But I didn't have a place of my own. And that place where we were staying was anyway a temporary matter.
So, am I right in assuming that you applied for this plot of land because you wanted to build a house?
Yes, obviously, at that time when I've applied for it in 2008, I had some hope for that. I had some dreams. So I had the intention. I wasn't thinking of going elsewhere to work. And my wife, she was working as a teacher. And we were expecting a child. And all the relatives of ours, the relatives were staying in the district of Sângere. So I was practically tying my future to that settlement. So I had the intention to build a house there.
I understand. You also mentioned that there was a delay of 4 years before you actually got the deed of the land. Why did it take so long?
Indeed, if we look at the decision regarding the appropriation of the land that was passed in February, on the 8th of February 2008 that was, and the land was actually given to me at the end of October. And that is confirmed not only by my words, but there is documentation in this regard. There is a decision of February 2008 as well, and the title deed was drafted on the 4th of October 2008, but it was actually registered on the 26th of October 2012, as far as I can remember, in the register of owners. And then there was this procedure for the handover and takeover of the land. And so it was the land given to me for ownership and use.
When it was registered, At that time, were you still planning to build a house?
Certainly, I still had that intention to build a house. That was the intention over years. I had never given up on it, although because of the position that I had been seconded to Chisinau. But even when I came to Chisinau, came to Chisinau, I was thinking about going at some point back to that settlement because I felt tied to the district of Sângerei.
You already mentioned that there were conditions in the decision of the municipality on the land that you received, and you are right. These were that you had to prepare project documentation within 3 months. You have to start construction work in 1 year, and you had 3 years for the completion of the house, so to speak. I'm going to ask you, but the answer, I think it's obvious. Did you fulfill those conditions?
No.
No, I did not fulfill those conditions.
Can you explain to the Commission why you didn't?
I will be very honest in answering this question. Actually, I received that land for ownership and use in October 2012. And in the summer of 2013, there was a tragical family situation. One of the close member passed away because of a road traffic accident. And then shortly after, another member got ill with a bad disease. So the focus is shifted onto personal issues. We've had a second child, and there was not enough funds to start building a house. And all of these factors together, made me keeping to postpone. I kept postponing the initiation of the building of the house.
You already mentioned, and it was also in your answers to the Commission, is that you, for the time that you were living in Sângerei, that you lived in the house of your in-laws.
Yes, that is correct.
So this means that when you applied for the land, you had a place to live, but it was your in-laws. You just had the right to stay there. Is that correct? Yeah.
That is correct. That is correct. It was a temporary place to live because the in-laws were quite understanding and we had a very good relationship.
Now we come to the point that it was from the documentation, but also your answers, you have sold this plot of land in 2021. And at that time, you had not started building a house. I think we can... Is that correct?
Yes, that is correct.
So you did not fulfill the conditions. If you look at the decision of the municipality, it states that if you do not fulfill the condition, the land needs to be returned to the municipality. Did you take this up with the municipality?
Yes, madam. As I said, I've always engaged in communication with the public authorities, and that communication was based on respect. We had open communication. And to answer the question of the Commission, that is why I wrote a request with the public authorities when the evaluation was underway. I've asked for general information as in whether any cases where a land plot was withdrawn for not having met the conditions, in order to prove that actually I did engage into discussions like this with public authorities. And I knew what the practice was, that I knew that they never exercised this right. The public authorities never exercised this right. I mean, there can be a personal opinion that I don't want to impose on anyone, but these requirements, when the town council imposed those requirements, they're not properly founded, because the law was clear that it shall be given gratuitously into the ownership of. So that was how the land was to be provided. But the mayor's office said that there were no situations like that of the land being withdrawn. And when the mayoralty drafted that title deed, it practically gave up its rights of ownership and it allowed me to have all the rights of ownership over that land. And it was up to me to further decide how I would use that property.
Is this something that you established at that time? Did you ask the municipality, can I sell the land despite these conditions? Did you ask them?
Yes, certainly, esteemed madam. And proof of the fact that I have been engaging in communication with the local public authorities and that I've informed them about my intention to sell it, proof of that is the documentation that I submitted at that time. When I was thinking of selling the land plot, the first thing I did was that I went to the Public Services Agency, to the cadastral bodies, and I've asked for some delimitation works, knowing that there is a little bit of a problem in terms of the boundaries of the land. And when those works were performed, actually there was a representative of the LPA, the local public authorities, present. And then what was a big question for me is that there were some trees on that land plot, trees that were there when I became the owner of that land. And thus, in order to not to have a conflict between myself and the authority, or between myself and the person who was going to buy that land. To avoid that, I filed a request with the local public authorities in December 2020, before the sale and purchase agreement was drafted, and I've sought clarifications. I said, can you please explain what is the tree tenure, like the legal regime for trees on that land plot? I have kept the trees there. I took care of the trees on that land plot. So how and what can I do now, given that I have the intention to sell this land plot? And it is in December 2020, before the sale and purchase agreement was signed, which was signed on the 15th of January, the mayoralty answered that as regards the trees, it is up to you to decide, because the land is owned by you, is your private property, and it is only up to you to make any decision in regards to that. So it was that wording, and also on the basis of the previous communication I've engaged in with the authorities, I knew there were no cases, and I knew that the local administration had no intention to withdraw, to take that land away from me. And also knowing there was Article 11 of the Land Code, and it was very clear, at least that's how it read to me, that gratuitously granted for free into the ownership of. That was the wording of the code. And given all of these, I believed it was possible for me to sell it. And I've sold it because there was a divorce in the meantime, and things changed totally. There was a total change.
We looked at a note that you sent to the municipality, and I'm going to read it to you. I'll just read it to you, and then I'll have a question. It says, I'm the owner of plot of land, and then a certain number, etc., located within the boundaries of Sinjere town, transferred by the town council free of charge, etc., etc. The plot of land in question was transferred to me in 2012, and at that time, linden and walnut trees were growing on it. Over the years, I protected those trees, but currently there's a need to take legal measures regarding this property. To avoid any potential disputes, I request the opinion of the local public administration as a former owner regarding the tree tenure applicable to the trees on the land. I do not see in this note any reference to your intention to sell the land. So can you explain to me how I should read it?
Well, when it said taking some legal measures, there was that point that I tried to word it like this. But the local authorities knew about my intention to sell it, and the proof of that is the fact that they were involved in those cadastral works for delimitation purposes to set the boundaries of the land plot. So that is proof of the fact that they knew that I was going to sell it. Right now, I cannot prove this other than by words. There was verbal communication between myself and the person who was responsible for examining that request, because that person called me as a person who filed that application to ask for certain clarifications. So it was a person from the mayoralty who was working in the legal department of the mayoralty.
Before I move to the next topic, I'm going to ask my colleagues if they have any questions on this topic.
Yes, I have one question. Could you explain, please, why restrictions stated in Sinjere municipality decision on 2008 were not mentioned or included in the state cadastral register?
Well, that's something that I've also asked myself. In that register, there are no notes regarding the encumbrances, regarding the rights. It's just that this is. They've used some previous wordings that they've used in other decisions, so that was their explanations. I did not get any other explanation from the authorities. But same as you, I've also wondered about it. So I've sought explanations, because the application, the first application was filed by my former wife, my ex-wife. And the decision was issued, though, in my name, and the first thing that jumped out at me is why the decision stated that the land is only to be granted to me, although my wife filed the application and we were a newly formed family and I was the man of the family, and therefore that was the decision of the council for the land to be attributed to you. And then there were the conditions that were imposed, and I sought some clarifications, but the clarifications were that, don't worry, there's been no case of a land having been taken away because of not having met the conditions. Because somehow, maybe they were thinking of initially putting more responsibility or accountability on the owners, maybe.
And another my question is how you assess your behavior regarding selling of land plot in Sinjere according to prosecutors' ethics codes.
Well, I've always cared about my conduct, my behavior, and I've never wanted to have not one single dent into my reputation for as long as I've been in Sinjere, but certainly this can be a subjective opinion. I do not believe that the fact that I've sold the land, I don't think that that impacted negatively myself or my family. And in general, I don't think it had an impact on the general system of the prosecutor's office. I did look into the evaluation materials, and I saw there is a document from the public authority, and that document is providing some clarification regarding this matter. And somehow, it practically reiterates what I've already stated, that it was my right as an owner. And as an owner, it was up to me to decide this is a right that was a right in perpetuity. And nobody could have. I mean, only as provided by the law, if there was some interest for some public interest, for instance, or if there was some need of the government, it was only then that the land could have been withdrawn.
Thank you for your answers.
I have an additional question now after listening to the questions of my colleague, because you just said that you, if I understand you correctly, and please correct me if I missed something. Am I to understand that you asked questions about the conditions in 2008 to the municipality?
Da, desigur.
Yes, of course.
Evident ca și dumneavoastră, la mine-
Obviously, similarly to you, I had this question because it is obvious from the text of the decision, and it disturbed me
Înțelegeam că
because I realized
puteam să îndeplinesc condițiile în termenii
I was not able to fulfill the conditions within that timeline that they set. Now I cannot confirm it with documents, but I went there, I talked to the authority who was supposed to enforce this decision, and I was given assurance. First of all, they asked me to be understanding that the local authority did not have available land plots at that specific time, so I had to wait. And yes, that's how it happened. I waited for 4 years and 8 months. That's it.
So, am I to understand that you were worried about the timeline to build the house?
Da, adevărat, eram...
Yes, indeed, I was concerned about the term for constructing a house, but I was not in a position to make requests to annul a document issued by a public authority because I realized at that time it was an issue to find the land plots and assign them,
Nu doar a mea, mai multor familii.
well, not only to me, but many other families. I know about several colleagues who have been waiting for years to get them. Not only colleagues, actually, generally. Young people who were getting married about that time, 2007, 2008, and later.
Okay, now, so if I remember correctly, you said somewhere after 2013, which was a traumatic year for you and your family. Is this when you decided not to build anymore?
Nu, atunci nu eram...
Not then.
Nu decidea să nu construiesc,
Well,
am decis...
by that time I haven't decided not to build. I decided that I would not build, or I was not able to build when we divorced and part of the family decided to stay in Chișinău. And since I had to fulfill my parental duties, I had to accept a position in Chișinău and stay here as well.
So, by that time, and I think this was 2019,
Da,
that you split?
2019.
Yes, 2019.
by that time you knew that you were not going to use the land for building a house. At that time, did it cross your mind that you maybe get in touch with the municipality?
Nu vreau să mă repet, dar...
I don't want to repeat what I said, but
Nu, să nu fie cu supărat.
just
În sensul, eu interpretam legea...
I interpreted the law in the way that that land plot was given to me as property, and as an owner, I'm managing that land plot. Moreover, I knew there have not been cases of repossessing land plots for not fulfilling those conditions.
This is something that you knew at that time, because I understand that you only recently heard this from the municipality, that they do not reinforce.
Nu. Nu, eu cunoșteam.
No, I knew about that. It's not calling a practice, but I was communicating with the authority, and I asked around how much it would cost, what would be the expenses for getting the design and project documents, how expensive would it be to build. So I was always wondering about that, so I knew what was the practice of the authority. What else can I say? I know that in case of a judge who moved to Sângerei, she asked the authority to fulfill the legal requirements for providing an accommodation for villages, and then legal professionals in that district were discussing about these aspects, providing a land plot for building a house, a possibility. Does the authority have a right to withdraw the land plot or not? But there have not been cases.
Thank you. Are there any other questions on this topic? I'm looking to Anna. Okay, thank you. We'll move to the next topic, and that is when you sold the plot of land, there was an issue with your report to the tax office. You did not declare the capital gains on this land to the tax office in your tax return for 2001. Is that correct?
I would like to explain to the Commission. You know, probably I provided enough data to the Commission, but I would like to highlight certain things. But I have always used the electronic system for filing returns, and a confirmation of what I say is in the data that is in the electronic tax return system. So on 29th of April 2029, in the appropriate timeline set by the authorities, I downloaded that electronic pre-filled tax return. I entered all data, I signed the document, and here probably I was not diligent enough. It was my mission, or maybe it was the mission of the IT system. I can't prove what it was, but if we look into my account on the platform of the tax service, there are times that the document, the pre-filled tax return, was drafted on April 29th, 2021, and it was signed. After that, I was confident that I filed the tax return in due time. I was not told about anything about that from authorities, but a couple of months later, at my own initiative, I wanted to go and calculate, because I was undergoing the process of discussions after divorce, and there was a question about that land plot. So, at my own initiative, I went to the tax service of Sângerei district, and I found that my declaration, my return, is not in the information system of the tax authority, and the tax officer told me it's not there. I tried to prove. I downloaded from the information system. I showed them proof that I signed that document on April 29th, and then the tax officer told me, unfortunately, it's not there. You just have to accept that the declaration or the tax return is not filed, and you will be you'll have a penalty for delayed submission. So the confirmation of what I say is reflected in the control report of Sângerei, and that states that the taxpayer came at his own initiative to the tax authority, and the tax officer showed me the contract, the sale and purchase, because it's known that according to an order of a state tax authority, a notary, when they draft such documents, there is an automated system that communicates or transfers data to the state authority. But also when I sold it on January 15, 2021, and I verbally told them about concluding this sale and purchase contract about that land, so I knew that I have to declare capital gains in order to fulfill my tax liability related to it. I was understanding. I accepted the position of the tax officer. I understood that I was not diligent enough to that end. I probably should have followed up if the declaration finally reached the system, but they drafted a tax control report. They calculated the tax liability, so I paid that tax related to capital gains and the sanction for the omission that I made. And this happened, from what I remember, in August 2022. Microphone, please.
There is a report about your visit, and that's from August 29, so you're probably right. So, just to recollect, because you have also given an account of what happened in your written answers. So, for me, it's not clear if the capital gains were also in the return that you posted electronically, or was this something that just came up when you visited the tax inspector?
Nu, eu evident că
No, obviously I am aware of my duty to fulfill tax liabilities, and previously I did fulfill my tax liabilities. I filed declarations on time. I never had the intent. I mean, it wasn't even possible for me not to declare capital gains because the tax authority had that data about the transaction. So it wasn't impossible to hide that. I mean, no, not even in my imagination would I think about that, to create something like this.
So, your conclusion is I tried to file it in 2021, that went wrong because of the system. So that's why I went to visit the tax inspector, and then you redid your tax return, including the capital gains. Is that correct?
Yes, it is correct. One comment, though. I can't say now that it was my omission for not being diligent enough, that I did not follow up, or it was a bug in the system. So I don't know. I can't say, because I remember I filled out the declaration together with some of colleagues of mine, and I was sure that I filed it on time, and I was somehow confident about it, but subsequently, I found out about that. I went to the tax office. It was my intent. It wasn't a control started at the initiative of the tax authority after finding a deviation. No, it was my initiative. So it wasn't, and it was not related to the launching of this competition, because someone from outside could say that, oh, I knew that I was going to run for this position, and then I decided to correct my financial behavior. No, this was in 2022, before I applied for this competition. Thank you.
I'm moving to my colleagues for further questions.
Mr. Șușu, I want to clarify if I understood it correctly. So you are saying about, you're speaking about the tax return for 2021 or for 2022? Or 2020? Which year are we talking about? The one that you did not file in the due time and you found in August. So it was August 2022, the declaration for 2021. So the electronic file was created on April 29, 2022. Now, in that document that was pre-filled, did you write, did you include the sale of the land plot there? Of course. I could not hide that. So it was there, it was mentioned there. And when the tax authority established two matters, not filing and delay in paying the tax. When I went to the tax authority got the information from the system that my declaration was electronically created, it was signed. My argument was not enough, so they started a control process, which was followed by a sanction for delayed submission of the tax return. they also calculated the income tax that I was supposed to pay as a result of the capital gain. I complied. I went and I paid 7,900, including 200 lei for delayed submission. Yeah, but the initial payment of the tax, did you paid that before August or not? No, no payment was done before. But in April you included that. Well, for me to be understood, the document, I understood that the document created by me was only stored in my account of the tax authority. It never reached the destination, the state tax service, and because of that, they couldn't have calculated and withheld those payments because in the end it was considered that the declaration, the tax return was not filed. It was filed with delay. But didn't you have to pay the tax? You yourself, I paid the tax. When? When the tax authority made the calculation. That was in August or after August. You did not pay before August. No, I did not pay before August. Why didn't you pay before August? It was not... I did not have a finding that I had to make additional payments to the state budget for capital gains. Thank you. I have no more questions.
Thank you. We'll move to the next topic. And those are the money transfers from your mother-in-law when she was in Israel. From the bank accounts, we have seen that you and your wife have received, I'm just going to get to the you and your wife received over the years 2008 till 2011 about $20,000. And we have asked some questions about this, and you have given some answers, and I will come back to those too. So, first of all, to establish, is it correct that you received that amount of dollars between 2008 and 2011? It's very close to $20,000.
Yes, that is correct. So together, myself and my former wife, we received remittances from her mother.
Was all the money that she sent, was it kept in the house? Because this is what you have said, you got the money belongs to your mother-in-law, and you kept it for her. Is that correct?
Yes, that is correct. Why did I... well, so one could ask, why did I take this position? I took this position of intermediary, like picking the money from the bank and taking it home for several reasons or circumstances. Very honestly, at that time, the husband of that lady was after heart surgery and he required medical care, so he could not physically go to the bank and get the money during that time. I mean, the year 2008, 2009. Then, after that, some of the transfers were made in the name of the lady's husband. So my wife was on child care leave in 2008, 2009. So that money was not an income of our family. We just kept it and we passed it. When she came back into the country, she took over because she earned that money.
Was none of that money that you and your wife received used for the upkeep of your household?
For some current repairs, on the decision of that husband of a real estate that they also lived in, because we lived in the same house. It was the husband of that lady was living with us, so it was his decision what investment, what repairs they could do. And from what I know, I mean, I was there. I can't say I don't know. Some things were being repaired, fixed, some current works, like the gas connection was established, heating system, some replacement.
We will come back later to the renovation and the upkeep of the house. Why was most of the money was sent to you and some of it to your wife? Do you know why your mother-in-law did this? Why didn't it all go to you or all to your wife? Is there a reason?
Decizia
No, it was her decision, how she deemed it appropriate, or depending on what she was when she had free time to go to a bank and make that transfer.
You mentioned a payment to your former father-in-law. There was one in 2009, and that was $4,550. That brings me to the topic of your father-in-law, because I understand he was living in the house as well, where you were staying with your family.
Da, de asemenea.
Yes, we were living together, so it was our family. And
when you moved in with your family into your parents' in-law house, your father-in-law has been there all the time.
Da, desigur.
Yes, of course. And the lady also, for some time.
Until she left for Israel.
Da, adevărat.
Indeed.
Did your father-in-law have an income at that time?
He has worked before that, but in the period when former mother-in-law went to Israel to work, he had a heart surgery, and I provided the commission, I think in May or it was May or April 2008 when that happened, and a part of the money was spent for treatment as well, and at that time he was not employed. For several years in a row he had no job. Then he got a certificate of disability. But later on, 2011, 2010, 2012, from what I remember, he was doing some work to the extent of his physical ability, even officially employed.
So how were the costs of the household divided between your family and your parents-in-law?
Evident că o parte din banii.
Of course, part of the money received as remittances from the wife he was spending for his own needs, and the expenses were divided. So we had a communication. Our parents-in-law were understanding, because both of us were working for the public authorities, so we could not commit to financially support him. So each of us was taking their own part of expenses in this joint living.
Now I'm coming to the repairs, because in your initial answer, you said the money that we received, I'm going to say you and your ex-wife received, that was her money. We kept it apart, and it was used for repairs and reconstruction of the house on Krylov Street, which is the property of your parents-in-law, ex-parents-in-law. Can you tell me who organized and ordered and paid the bills for these reconstructions and repairs? Who was in charge of that?
To the extent possible, I tried to submit to the Commission documents that I obtained from my former parents-in-law, actually, as well, about some works, what was possible. They incurred the expenses for instance, connecting to the gas system, installing heating system inside, and further expenses for bills and contracts were all signed in the name of Constantin Kazaku.
We noticed, and I think you did a good job in reconstructing what has been done to the house. I mean, it's a long time ago, we understand. But I'm still trying to establish how much of the $20,000 of your mother-in-law was used for this purpose.
Honestly, I was not keeping record of those expenses. From what I recall, for instance, known things that connecting to gas and like having these works designed and the works themselves, they cost around 11,000 lei. For instance, the gas boiler was around 20,000 lei. And I know that after that they changed the roofing on the house and they spent around 80,000 lei on that. In 2012, I know that from the money of my former mother-in-law, they purchased a Renault Megane SGAO 095. That was the number plate. That's from what I know. Because, well, we were a family, but you know, when it comes to money, I was not having full access. Moreover, since I was the son-in-law, but we had a good relationship.
Members, if they have any questions on this? No? Okay, thank you. I'm moving to the loan that you took from the Victoria Bank in 2008. This is a loan of 30,000 lei, and you have stated before that this loan was used for repairs of the house, which is something else than renovating the house, I think. Yeah. And you have stated that you used the money that you got from your mother-in-law to repay the loan. Is that correct?
Yes, that is correct. I state that. Full accuracy indeed. I contracted a loan. I used the money for current repairs, and that's what the money was spent for. After that, the current repairs of the Kazaku spouses, because we just had the right of habitation, and our family was growing, some adjustment, repairs of a dwelling was necessary. So I got the loan, money was invested in their house, in parent-in-law's house. That's why the mother-in-law took over the repayment of that loan, and that's proof the early reimbursement of the loan. Money came from the remittances coming from abroad. Because I obviously, from a prosecutor's salary, I did not have enough resources, because payments were made, for instance, in 1 month with 1,800, and in another month the payment was more than 4,000, and I did not have a possibility from my salary, my wife's salary, to repay that loan.
That brings me to the question, what did your family contribute to the household costs? Did you pay rent? Did you, because these repairs are of course necessary for the house of your in-laws, but you live there as well. So what did you bring in the household for financial means for the household? What did you pay for?
Eu nu pot să zic că am contribuit
Well,
atunci.
I can't say specifically that I've contributed to, because I had this gratuitous right of habitation in that household. As for the maintenance expenses, the mother-in-law would pay, and that is not an expense of my own, as she was paying for that. I don't have a right whatsoever now, and I would never ask for to be paid back for having contributed, for instance, for having contributed to the current renovations or to improving the appearance of the house. I wouldn't ever be able to demand that back because I've never paid for it, and all the money that was invested, all that money belonged to the family of the owner. That was not my money. And I made no payment in terms of rent. I did not pay rent for that entire time that I stayed there, from 2007, from October 2007 and until August 2008, for as long as I've lived there. I did not pay rent at all.
Okay. Questions? I'm moving to, I have some questions on no, I think these are basically answered. So, that's all done. Then I have one final topic that I would like to discuss with you, and this is a reprimand that you got in 2008, and I think it made a big impression on you, so you probably know what case I'm referring to.
Da,
Yeah.
da, evident.
Yes, certainly. And indeed, when I was filling in the integrity questionnaire, I've let the Commission know about the fact that there has been such a sanction in my professional past. After that, I've had no other situations of this kind, no other sanctions, indeed, that has left an impression on me. And back then, at that time, I thought that I did the right thing, as provided by the law, as per the code of criminal procedure, as per my duties. I admit that I might have overlooked certain things. I mean, that I haven't filed a notification, a subdivision of the Prosecutor General's office. But there was the rules weren't that clear. There were some rules, and when you were initiating a revision procedure, you were supposed to inform that particular subdivision of the Office of the Prosecutor General. My idea was not to open that decision on revision, but then there was a decision of the court that compelled me to initiate that revision. Then I went back to court, and there was a notification rather to reject the initiation of the revision. That was the application that I went to court with. But then I accepted that sanction that was imposed on me in 2008. And now, well, a lot of things have changed. Back then, the decision-making power of the Prosecutor General in disciplinary procedures was absolute, and there was some subordination that was, well, some administrative and hierarchical subordination, and this was quite stronger when it came to the relationship with the Office of the Prosecutor General. And there weren't really mechanisms to challenge, to appeal against sanctions, but somehow formally there's also been this something that I've overlooked, an omission on my side, that I did not engage in enough communication with that particular subdivision of the Office of the Prosecutor General.
Thank you. That was obvious from your written answers, but I have a few questions, and just to sort of frame the case, it was a case against a minor who was convicted for a sex crime. And initially the minor got a prison sentence of 5 years, and it was reduced to 1.5 years after a review of the case. And my question is, did you know the suspect or the victim personally?
No, I did know them, and that case was even not initially, I was not even initially responsible for that case. There was a different prosecutor. But I would like to make certain corrections. The victim was a minor, a male, a boy, not a girl. But regardless of that, the minor was not 5 years old, and the person who committed that was also a minor. They were close in age, but I knew none of them.
I did not say it was a girl or that it was 5 years old. I think you may have misunderstood me. Never mind.
Да.
Perhaps. I mean, I just...
Never mind. Never mind. Okay. And I think the substance of the reprimand was that you did not inform the Office of the Prosecutor General of the review procedure. Is that correct?
Да, correct.
Yes, that is correct. And it was also claimed that when the prosecutor was, well, there was a prosecutor that made a synthesis of the aspects regarding revisions, and that sentence was to be challenged.
Could you tell us why the sentence was reduced and what your opinion of this reduction was? Did you advise the court to reduce the sentence?
În procesul
In the course of the examination, when the court accepted the application for revision, the defense introduced new circumstances. As per the law, there were new circumstances as to the suspect, regarding the suspect. And the court accepted the evidence filed by the defense in that regard, and it reduced the sentence of the accused from 5 years to 1 year and 6 or 8 months.
And was this your advice to the court to do that, to reduce the sentence?
No. My recommendation in this regard, my recommendation had nothing to do with reducing the sentence. The defense introduced new circumstances as per the revision procedure requirements, and the panel of 3 judges examined it, and they've decided that they would reduce the sentence given the new circumstances. Ultimately, after the sentence was handed down, that sentence was coordinated. Now, I cannot provide proof of that, but it was coordinated with the representatives of the Office of the Prosecutor General, and it was accepted at the time that the sentence was legal and there was no need to do anything else about it. And then, considering the documentation that had been filed, it said that that sentence had been discussed and that that sentence was legal and there was no further action was required. No further action was required.
Any more questions? Yes.
Just to clarify, to make sure that I got it right, so your decision was not to reopen the procedure initially, is that correct? Yes. And then that decision had been challenged. The decision was challenged, and the investigative magistrate compelled me to, and then I took court, then I sent that decision on revision with a note of rejection. But then the 3 panel judges looked into my decision, and they decided that, they've reviewed the application for revision. Ultimately, they decided that it was necessary and legal to initiate the revision procedure, and they ordered the revision of that particular case. All right, and the disciplinary sanction was for you not having informed the Office of the Prosecutor General that the court decided to reopen it. There was an institutional rule that within 3 days from the moment that the revision procedure is opened by the prosecutor, so within that period of time, within 3 days, I had the obligation to file a report. As the chief prosecutor, I had to inform that subdivision of the Office of the Prosecutor General of that particular circumstance. And at the time, I've interpreted it in the following way, because initially my decision was not to open revision. My decision was to refuse to deny opening the revision. It was clear, though, that I should inform them if revision is opened, but I had the other decision. Then the investigative magistrate compelled me to open the revision procedure. I again filed a notice that I was denying the revision. But then another question, a last question, if you remember, during the revision already, you thought that the initial judgment should have been stayed intact. When I've looked at the revision application, there was the defense, they brought in the evidence, and there were some new circumstances that have emerged, and it was accepted thus that there would be a revision of the decision of the court, the initial one, to reduce the sentence. And as for the reduction of the term, well, yes, since I did not appeal against it, it meant that I've accepted it.
I have no further questions. Thank you.
Thank you. I'll just make sure none of the commissioners have any additional questions. Thank you, Mr. Șușu, for your time today. I'll give you some opportunity now if you'd like to make a closing statement for the commission.
Thank you for your openness. I was absolutely open for engaging in communication. I've always exercised my profession as a prosecutor with devotion, and I cared a lot about the prestige of this profession of prosecutor, and I always cared about the credibility of the entire system. So I define integrity as something that is, well, it means being honest. And when you stick to some values, when you have some values that you stick to no matter what, and that's why that was what served as rules for my work as a prosecutor. I have always been aware, and I've always known that the professional prestige and reputation is something that we all contribute to. I contribute to that as well, to the reputation of prosecutors, and I do that by being honest, fair, loyal. But one needs to have many other qualities for that purpose, and it's also about the reputation and the prestige of the profession. When it's practically we, the prosecutors, are doing it, are working towards that, are building that. When you have a proper, high-level work culture, when you implement the professional instructions and directives, and when you show enough diligence when you do that. As far as the evaluation that I was subject to, I must say that this has taught me a lot of lessons. First of all, there has to be a lot of engagement, there has to be a lot of openness, one has to be fair, honest, coherent, consistent, and one has to be very diligent. Certainly, there can be certain incommodities, but I think that is absolutely normal, and I've understood all of the stages, and I tried to be as honest as I could in my communication with the Commission. Certainly, regardless of the decision that the Commission will make, well, that'll have, though, an impact on my professional future, though, I believe. It might be a negative impact, though I am very optimistic that there will be a positive impact. And I really trust this external evaluation process. Despite the criticism out there, I see it as a positive one from two perspectives. There's a personal and institutional perspective. As for the institutional perspective that I look at this through is that Moldova has now undertaken certain commitments given the negotiations to join the EU, and we, the prosecutors, are also part of it. We're not sidelined. We're part of this community, and we also have some obligations of our own in terms of the commitments undertaken by the country. And mainly, it is important for our behavior to be up to the unanimously acknowledged standards. We need to have the profile of European prosecutor to be fair, just and all the other things. And then personally, the findings that I see in the documentation of the Commission, they can be used as guidelines, for prosecutors to follow in the future of their work when it comes to financial matters, ethical matters. The clarifications that we see are very useful for prosecutors to follow. This is what I can see from the inside of the system. There have been situations of dilemma. And thanks to the decisions of the Commission, for instance, there were some findings, some remarks regarding different people it evaluated, and they were useful. Prosecutors are part of the system. They do not live in an ivory tower, and there can be certain omissions, something minor, some minor mistakes, something that would be such, though, that would not amount to giving a bad impression regarding a person. But it is important, though, for one not to act in ill faith. Lastly, I would like to say that I have confidence about this process, and I'm optimistic that the result of the entire procedure of external evaluation of prosecutors will lead to enhanced credibility in this institution, prosecution service. And I believe that we will make it through, and that hopefully as soon as possible we'll have members to the board to make the entire prosecutor service operational. That's my closing remark. Thank you.
Thank you very much. And we thank you for your participation both in the evaluation process and at the hearing today. The Commission will now deliberate on the matter and issue a decision as soon as possible. I declare the hearing to be closed. Thank you.